Right. So this topic will be presented by myself, Nomfundo Ntuli, Nico Matebula, and Thuweba Musisi. So the HPCSA's ethical guidelines for good practice in the healthcare professions consist of booklet 1 to booklet 17, basically outlining the various guidelines for all healthcare professions. It is available on the HPCSA website if you would like further in-depth knowledge about these guidelines. We will briefly be going through booklets 1 to 15 as they relate to specifically the medical profession that we're in. So the beginning of each section highlights the spirit of professional guidelines. And essentially this says that practice as a healthcare professional is based upon a relationship of mutual trust between patients and healthcare practitioners. Good healthcare practitioner requires a lifelong commitment to sound professional and ethical practices and dedication to the interest of one's fellow human beings and society. HPCSA ethical guidelines are used to guide and direct the practice of healthcare professionals. They also form an integral part of the standards of professional conduct against which a complaint of professional misconduct will be evaluated. So booklet 1 is the general ethical guidelines. So being registered as a healthcare professional with the HPCSA means that you have the right and the privilege to practice. Correspondingly, practitioners also have the moral or ethical duty to others in keeping with the principles of the South African Constitution. The first booklet of general ethical guidelines contains value-oriented principles and ideals to which healthcare professionals should subscribe. More specifically, ethical guidelines and rules are derived from these general ethical guidelines. The precise guidance and direction are provided by each board. However, it is impossible to develop a complete set of specific ethical prescriptions applicable to all conceivable real-life matters. Professionals have this to work them out themselves using ethical reasoning. This booklet lists 13 core ethical values and standards that underline professional and ethical practice in healthcare professions and gives a short explanation of how one makes practical decisions through clinical reasoning and ethical reasoning, sorry. So core ethical values and standards for good practice. Everything ethically required of a professional to maintain good professional practice is grounded in core ethical values and standards. The directives that follow are the core values. So we all know the 4 basic principles of medical ethics, and these include autonomy, beneficence, non-maleficence, and justice. Beyond these, we are also required to have respect for persons, integrity, truthfulness, compassion, professional competence, and community. So how do we resolve ethical dilemmas? The core values and standards referred to above are the foundation that grounds the general ethical guidelines in these booklets. How healthcare practitioners may use these guidelines to make practical decisions or choices above the provision of health care. In specific cases, we do this through ethical reasoning, and this occurs in the following 4 steps. Firstly, we formulate the problem. Then we gather the information relevant towards this problem. Then we start considering our options. And from this, we make a moral assessment. And this involves taking into consideration the consequences of each option, the most important values, duties, and rights, the weaknesses of the healthcare professional, and the personal preferences of all those that would be affected by this. After this, we discuss our proposed solution with those who it will affect, act on said decision, evaluate, reflect, and then adjust for the future so that we may make the best decisions going forward. Healthcare practitioners fulfill different roles and obligations according to the various duties that they have. So the different duties that we may have is firstly natural duties that we have as human beings. These include things such as doing no harm and promoting good. Next, we have as professionals, we have moral obligations, which we acquire by being qualified and licensed as professionals. These are contractual obligations we have, such as relationships with the patients that we treat. Following that, we have institutional duties, which are imposed upon healthcare practitioners working in specific institutions, such as being employed by the government or in private practice. Finally, we have legal duties, which are imposed by common law and the statute law, such as National Health Act or the Health Professions Act. It is important to remember that no duty is absolute or holds without exception. Also, there's no list of such duties that is ever complete. Any classification of duties is arbitrary because specific duties may be owed to different parties simultaneously. In book 2, we will be discussing ethical and professional rules. So this booklet contains the draft regulations concerning the ethical and professional rules that the Health Professional Council has recommended to the Minister of Health. These rules govern the conduct of all professionals under HPCSA. Interpretation and application of these rules include knowing that failure by a practitioner to comply with them would result in the board concerned taking disciplinary actions against a said practitioner. Conduct determined in these rules shall not be deemed to constitute a complete list of conduct, and the board concerned may therefore inquire into and deal with any complaint of unprofessional conduct which may be brought before such board. At an inquiry, the board concerned shall be guided by these rules and ethical rulings or guidelines and policy statements which the board concerned or council makes from time to time. The type of rules in this case pertain to issues such as advertising and canvassing, professional stationery, practice names, fees and commission, room sharing, appointments, medical and medical devices, human organ retention, and many other rules, which you can read further in the HPCSA guideline. Booklet 3 is about the National Patients' Rights Charter, which is developed by the Department of Health in consultation with various other bodies. As we know, the purpose of this is to ensure the realization of the right to access to healthcare services as guaranteed in the Constitution of the Republic of South Africa. I will not go further into this as we've discussed it last week. In booklet 4, we will be discussing the ethical considerations of informed consent. So patients seeking this booklet sets out the principles of good practice, which all healthcare practitioners are expected to follow when seeking patients' informed consent. As we know, successful relationships between healthcare practitioners and patients is dependent on mutual trust. Practitioners must respect patients' autonomy and their right to decide, and that is how we maintain the trust between the two bodies. The right to an informed consent flows from the South African Constitution, the National Health Act, and various other statutes, such as the common law and any HPCSA guideline. The law prescribes the minimum requirements when seeking informed consent. Effective communication is key to enabling patients to making informed consent. When seeking consent to investigate and treat, the role of the healthcare worker is as follows. It is to provide sufficient information, including the patient's health status, the range of diagnostic procedures and treatment options, the benefits, risks, costs, and consequences thereof, the patient's right to refuse health services, and explain the implications of refusing. It is important for the practitioner to respond to all questions raised by the patient, to do so fully, accurately, and as objectively as possible. The practitioner should also not withhold any information necessary to decision-making unless they judge that disclosure of some relevant information would cause the patient serious harm. Obtaining informed consent cannot be an isolated event. It involves a continuing dialogue between the healthcare practitioner, the patient, and the various teams involved. So who exactly has the right to consent, or rather the responsibility to consent the patient? A healthcare practitioner providing treatment or undertaking an investigation has the responsibility to discuss it with the patient and obtain consent. Where this is not practical, the healthcare practitioner may delegate these tasks provided They ensure that the person to whom they delegate is, number one, suitably educated, trained, and qualified, has sufficient knowledge, acts in accordance with the guidance in this booklet, and the healthcare practitioner will remain responsible for ensuring that the patient has been given sufficient time and information to make an informed decision. Ensuring voluntary decision-making. It is for the patient and not the healthcare practitioner to determine what is the patient's own best interest. Health professionals' role in this regard is to give a balanced view of options, to explain the need for informed consent, to declare any potential conflicts of interest, and they have to do their best to ensure that the patient have considered the options and have reached their own decision. They need to take appropriate action if they believe patients are being offered inappropriate or unlawful financial or other rewards. We also have to ensure that the vulnerable patients know that they have the right to decline any treatment or investigation, and make sure that we uphold that right. In emergency situations where consent cannot be obtained, healthcare practitioners may provide medical treatment that is limited to what is immediately necessary to save life or avoid significant deterioration in the patient's health. However, healthcare practitioners must respect the terms of any valid advance refusal by the patient. After the emergency health care has been provided, the practitioner should tell the patient exactly what was done and why. So establishing capacity to make decisions, healthcare practitioners must work on the presumption that every adult has the capacity to decide whether to consent or refuse. If the patient's choice appears irrational, that in itself is not evidence that the patient lacks competence. In such circumstances, it must be appropriate to review with the patient whether all reasonable steps have been taken to identify and meet their information needs. In cases where there's fluctuating capacity, where there's difficulty retaining information or only intermittently competent, practitioners should provide any assistance that the patient might need. They should also record any decisions made while the patient was competent, including any key elements during the consultation. Thereafter, the practitioner will review any decisions made while the patient was competent, in order to establish views that are consistently held and can be relied upon. In the case where we have mentally incapacitated patients, the National Healthcare Act makes provision. It also sets out a priority list of people who may consent. Firstly, it would be a person authorized by the court, or in the order of a priority being a patient's spouse, a partner, a parent, a grandparent, a child, or a brother or sister. In the case of children, the Children Act stipulates that a healthcare practitioner must assess a child's capacity to decide. In general, a competent child is allowed to consent. We have to take account of the following: that a person who's over the age of 18 is considered an adult and is legally competent. A child who is 12 years old and is legally competent to consent if the child has sufficient maturity and mental capacity. In children under the age of 12 or not sufficiently matured, they do not have the necessary mental capacity, and the parent or guardian may give consent. The superintendent of a hospital or the person in charge is also allowed to consent if treatment or operation is necessary to preserve life or to save the child from serious or lasting physical injury. The Minister of Health may also consent if the parent or the guardian of the child unreasonably refuses to give consent. The High Court or Children's Court may also consent where another person that may give consent refuses to or is unable to. No parent or guardian or caregiver of a child may refuse to assist a child or withhold consent by reason only of religious or other beliefs. In South Africa, a female of any age is legally competent to consent to termination of pregnancy, as long as she has the necessary mental capacity. In cases where the health practitioner needs to decide, we utilize the principle of best interest. The various types of consent include the following. We have expressed consent, where the patient can indicate their informed consent either orally or in writing. Except in emergency situations where the patient has the capacity to give consent, healthcare practitioners should obtain written consent in the following cases: in treatment or the procedures that are complex or involve significant risks, providing clinical care that is not the primary purpose, where there may be significant consequences for the patient's employment, social, or personal life, or if the treatment is part of a research program. Some statutes require particular forms of consent to be obtained for specific procedures, such as sterilization, termination of pregnancies, or the removal of organs from a dead body. Implied consent occurs when the patient presents to a health institution for help. It encompasses basic interventions such as diagnostic and treatment. However, submission in itself may not be necessarily consent on behalf of the patient. Lastly, Book 5 is about confidentiality. The National Healthcare Act states that patients have the right to confidentiality. It provides that this information must not be given to others unless the patient consents or the healthcare practitioner can justify the disclosure. Practitioners are responsible for ensuring that their clerks, receptionists, and other staff respect confidentiality in their performance of their duties. The Rule 13 of the Ethical Rules of HPCSA states that the practitioner may divulge information regarding to the patient only if it's done in terms of statutory provision, instruction of court, the public interest, with the express consent of the patient, written consent of a parent or a guardian for a minor under the age of 12. And finally, in the case of a deceased patient, we need written consent from the next of kin or the executor of a deceased estate. Mr. Weber will be taking over from me.
Good afternoon, everyone. So I will be commencing from booklet 6, which speaks of the guidelines for the management of patients with HIV or AIDS. So it is important to remember that our primary responsibility as healthcare practitioners is to our patients, and therefore it is against all ethical and professional rules for a healthcare practitioner to refuse to treat a patient solely on the grounds of the latter's perceived or actual HIV status. Treatment should never be suboptimal because of a perceived potential HIV risk to the healthcare practitioner. Unilateral decisions not to resuscitate patients with HIV are violations of fundamental human rights. It is also ethically and legally mandatory to get informed consent before a healthcare practitioner tests a patient for HIV. By law, this always applies except in a medical emergency or in the case of a child where a parent or guardian is required to give consent. Healthcare practitioners must support all measures aimed at preventing HIV infection. Such measures include appropriate education regarding HIV infection, alteration of lifestyle, improved management of predisposing and aggravating factors, including other sexually transmitted diseases, as well as mobilizing support from the community and disseminating information regarding preventative measures. The test results of HIV positive patients should be treated with the highest possible level of confidentiality. With regards to partner disclosure, the healthcare practitioner should use his or her discretion when deciding whether or not to divulge the information of the patient's sexual partner, taking into account the possible risk of HIV infection to the sexual partner and the risks to all parties involved. If the patient still refuses, further counseling should be done and a decision should be made regarding the disclosure. Then healthcare practitioners cannot be obliged to disclose their HIV status to an employer, nor may any healthcare practitioner be unfairly discriminated against or dismissed as a result of his or her HIV status. Then moving on to booklet 7, which contains the guidelines for withholding and withdrawing of treatment. So the clinical responsibility for decisions A decision to withhold or withdraw life-prolonging treatment should be made only by the senior clinician in charge of a patient's care, taking into account the views of the patient or those closest to the patient. Before a decision is made to withhold or withdraw treatment, the treating healthcare practitioner must carry out a thorough assessment of the patient's condition and the likely prognosis, taking account current guidance on good clinical practice, and all options for treatment that are used should be up to date and based on the best evidence that is out there. And when making these decisions, the patients should always be, their view should always be considered if the patient is competent. Then healthcare practitioners should hold discussions at a time when the patient is best able to understand and retain information. So timing is very important. Then all decisions that are made should be communicated adequately and recorded and documented well. Then moving on to booklet 8, which has guidelines for reproductive health. As healthcare practitioners, we have an ethical duty to be advocates for women's healthcare. Healthcare practitioners are obliged individually and as a profession to monitor and publicize indices of reproductive health and provide data to sensitize the public to health issues and rights of women. The informative function should not be limited to quantifying the problem, but they should also identify social and cultural causes in order to develop appropriate strategies for improvement. Practitioners should inform the community about problems of sexual and reproductive health and promote a wide debate in order to influence health practices and legislation. With regards to intimate examinations, professionalism in the practitioner-patient relationship should always be upheld. And in most cases, it's always advisable to have a chaperone present during these intimate examinations. Then when it comes to violence against women, it is important for healthcare practitioners to recognize cases. Documentation must take into account the need for confidentiality to avoid potential harmful consequences for the women. And this may need separate, non-identifiable compilation of data. Then the next step would be to treat the physical and psychological results of the violence and also affirm the patients towards them not being the cause of what has happened to them. It's also very important to just advocate for social infrastructures to provide these women with secure refuge and ongoing counseling. And then moving on to booklet 9, which just speaks of patient records, and it reiterates how important it is to take good legible notes and always sign off your notes. And then booklet 10, lastly, just speaks of telemedicine, and it has guidelines regarding the practice of medicine using electronic communications, information technology, or other electronic means between a healthcare practitioner in one location to another. So telemedicine, as defined, refers to where information is exchanged electronically, either on or offline. And according to the HPCSA, the consulting practitioner remains responsible for the treatment, decisions, and other recommendations given to the patient, as well as for keeping detailed records of the patient's condition and information transmitted and received from the servicing practitioner. Thank you. I'll now hand over to my colleague, Nico.
Nico?
Okay,
will you just try and keep it to 5 minutes to finish?
Okay, I'll be brief. Okay, okay, so I'll be picking up from booklet 11. Booklet 11 speaks to financial matters, mainly over-servicing, perverse incentives, and related matters. So essentially, over-servicing is when there is supply provision or prescription of treatment that is not medically or clinically indicated, is unnecessary or inappropriate, or is not in accordance with recognized treatment protocols and guidelines, or isn't in the best interest of the patient. The booklet also speaks to perverse incentives, which are defined as money or any other form of compensation or payment that is not legally due, or which is given with an understanding in the context that is illegal, contrary to professional rules and guidelines, or affects the best interests of the patients. Other rules contained in booklet 11 pertain to manufacturing of medicines and medical devices, referrals, use of technological equipment, ownership and financial interests in hospital or healthcare institutions, contracts and legal agreements, as well as charging of fees for services rendered. Booklet 11 speaks to management of healthcare waste, which is defined as any undesirable or superfluous byproduct, emission, residue, or remainder generated in the course of healthcare. And the reason why this is important is because healthcare waste, if handled improperly, has the potential to harm people, property, or the environment. So in this regard, all human anatomical waste, blood and body fluids are considered to be potentially hazardous. For the purpose of these guidelines, the following should be considered to be hazardous healthcare waste. So that includes infectious waste, pathological waste, sharps, pharmaceuticals, chemicals, heavy metals, radioactive substances, and those listed. Management of healthcare waste. So according to the guidelines, it's the responsibility of healthcare practitioners to have healthcare waste management systems in place. And this system should be provided by an accredited waste service provider and should be conducted in accordance with the relevant legislation, such as the Code of Practice of SABS on the handling of human waste and waste material. Therefore, the healthcare waste management system should be comprehensive and should have measures for waste minimization, segregation, packaging, labeling, storage, and removal. Furthermore, healthcare practitioners have an obligation to report evidence of unsafe disposal or management of healthcare waste by any persons. Booklet 13 is about ethical guidelines for health researchers, and that is guided by 5 principles that I'm sure we're all familiar with: non-maleficence, beneficence, autonomy, confidentiality, and justice. In the interest of time, I won't elaborate on that further. So in research, the responsibilities of researchers include respecting research participants and acting in their best interest, ensuring impartiality and justice, incorporating research and the outcomes thereof into medical practice, ensuring that they are qualified to conduct the research in question and do so within the constraints of their knowledge and skills. Healthcare researchers are also responsible for reporting any scientific misconduct, as well as conforming to relevant legal requirements. Furthermore, healthcare researchers should ensure that they receive approval for their research products from all relevant ethics committees. They're responsible for the care of any animals used in research, as well as the environment if it is impacted by the study. Booklet 14 is about ethical guidelines to biotechnology research. So the same principles and practices described in booklet 13 apply. The last booklet I'll be discussing is about research, development, and the use of chemical, biological, and nuclear weapons. So healthcare practitioners are committed to the preservation of life and alleviation of human suffering. It is thus completely contrary to the fundamental principles of ethics for healthcare practitioners to participate in research or activities directed at generating materials intended to cause harm for human health and well-being. So this booklet exists because if you look in our history, the TRC found that the apartheid government had a covert program for the development of chemical and biological weapons and had recruited healthcare professionals and scientists to staff this program. This obviously has led to the development of these guidelines for participation in such programs. But I think the takeaway point from here is that all research to design chemical, biological, and nuclear weapons is unethical. And should a healthcare practitioner find themselves in a situation where they are coerced or are experiencing pressure to participate in such research activities, they can appeal to the HPCSA and other professional bodies for support.
Is that the last?
I have one more slide. I'm just struggling to change over to that page. Okay, I'll leave it there, Prof. So I just have two other booklets that we didn't cover. There's a booklet on the use of social media, which I think it's important for us to familiarize ourselves with, as well as a booklet on palliative care. So this is all available on the HPCSA website if you want to read further. Thank you.
No, thank you. I know it's not very easy to take 17 booklets and somehow cram them into 25 minutes. And thank you. The idea was for you to have a quick sweep of these and have a sort of high-level understanding what exactly these are. You've done them a long time ago. Sometimes you forget, and you can just revise some of that. Just to remind that, in terms of the hierarchy of you might say, ethical guidance, it starts with the law, and then it goes to sort of ethical rules and guidelines that are established by the profession. And then you might look at patient choice, I think, and sort of institutional requirements. Institutional requirements are actually right at the bottom. So be very careful of letting the institution push you into making decisions that are unethical. So just thank you for that. I think the group did well. Let me stop there.